Hi, I'm Warner Jones with Carter Shelton Jones PLC and EstatePlanningTN.com. Today, I'm going to talk about what happens if you pass away in the state of Tennessee without a will. And I'm going to give a couple scenarios, basically the, for lack of a better term, best case scenario. And then we'll talk about what happens if you don't have things organized on the front end. So there's really a few assets that everybody kind of needs to coordinate to avoid issues in estate planning. So we've got the house, bank accounts, brokerage accounts, retirement accounts, and any business interests or trusts. So the bank accounts are easy. We just make those joint or payable on death. The retirement accounts in life insurance have beneficiary interests where you designate the beneficiary. And the house can be owned by tenants by the entirety, husband and wife. In that scenario, the surviving spouse basically takes everything outside of probate. The house is in their name. The bank accounts automatically go to them. Retirement accounts and life insurance name them as the beneficiary, so they get that outright and free of trust. And in this scenario, we don't have any business interests or trusts to deal with. Now, if there are kids, the fact that they've got all these things titled correctly outside of probate means that you don't have to open an estate, and there's no issue under Tennessee law with children getting any assets. The problem is if you don't have everything designated, or if there's just one straggler account or one spouse has a piece of real property that's only titled in their name, now we're going to have to involve the court to make sure that the state of Tennessee's intestate laws are used and that all the assets go where they're supposed to go. Under the state of Tennessee's intestacy laws, the surviving spouse is not entitled to receive all of the property from the spouse that passed away. There's a component that allows the children to have a certain percentage that's based on a formula that's in the statute. So I've attached a copy of a one-sheeter that gives a little bit more detail on what that formula looks like and what the different circumstances can be. But if the children inherit through the intestacy process, they're going to need to have a legal guardianship if they're under the age of 18. The legal guardianship process is a pretty strenuous one on a surviving spouse. The surviving spouse is going to have to hire an attorney to file a petition to become a legal guardian, even though they're already the guardian for physical purposes. They're not the guardian for financial purposes. This process is there to make sure that no adult takes advantage of a minor child who had a parent pass away. Those assets are technically the child's assets, and so any person that's going to be taking care of those assets for them is going to have to operate under court supervision. The court supervision requires a petition, an inventory of all the assets that that child inherited, an annual accounting, and you're going to have to post bond. So the financial problem with this is that you're going to have to pay a certain percentage of the assets that are in the child's guardianship as insurance through the bond process. The next part is you're going to have to pay an attorney to open an estate. And so they're going to have to draft the documents, file the inventories and accountings, and keep up with that. It can be a really cumbersome process as well. There's a lot of court dates that you have to attend, and the minor children are just kind of left there with an account that has a lot of restrictions as opposed to a trust. Another scenario that starts becoming problematic is if something happened to both spouses. Now, when the surviving spouse passes, or if both spouses pass it at the same time, that's when we're also going to have to deal with the court to pick the guardian and to make a legal guardianship for financial purposes. So the scenario that we talked about, having someone required to do all of those activities in court, including a petition, accounting, inventory, and posting bond, they're going to have to do that if something happens to both spouses. And it's going to be a lot of stress to put on someone who's probably taking care of the kids, along with dealing with court issues and the whole mess around both parents having passed. So to summarize, there is a circumstance where the outcome wouldn't be an awful one if something happened to one of the spouses. But in both circumstances, if both spouses pass away, you're really looking at a problem, especially if you have minor children. So take a look at the attached handout and see exactly what would happen if something happened to you and you didn't have a will in place, and then you'll know kind of where everything would go and how children will be involved. Again, I'm Warner Jones, and I'm with Carter Shelton Jones in Estate Planning Tennessee. And the best way to reach me is at warner@estateplanningtn.com.